Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's Legally Speaking video, I would like to talk to you about what you can do if you filed for asylum and now you have an employer who's willing to sponsor you for your green card. Well, it all depends actually when you filed for asylum and what status of any you had prior. What happens for employment-based cases is that the law does allow you to be out of status for the purposes of adjustment based on approved I-140 petition, but only if you you've been out of status, did not maintain lawful legal status in the United States for less than 180 days. Okay, so if, for example, the window was between your different statuses was too long, more than 180 days, then that exception will not work. Okay, now asylum. Asylum is not really a status. Asylum pending is not really a status. It's authorized stay. It's not a lawful non-immigrant status that would allow you to not to have that gap, the gap that you cannot have of more than 180 days. Okay, so that's very important, meaning that, for example, that you enter the country on January 1st, okay, on May 1st you filed for asylum, and let's say we're in the year of 2020, May 1st 2020 you filed for asylum, you entered the country on January 1st 2020. In July of 2021 there is an employer whose employment petition is approved, and they say, well, why don't you just file for adjustment of status? You will not be able to do that, because when you filed for asylum, it did not convey any lawful non-immigrant status on you, like F visa, H visa, L visa status, and so on. All right, you were just permitted to stay in the United States. But an interesting part of this whole analysis is this: if you manage to file your asylum application within 180 days prior to expiration of your status, right? You didn't have unlawful presence for more than 180 days, then you can, in theory, leave the United States and get an immigrant visa and come back, because then you will not be subject to the unlawful presence bar. So that's very important. Okay, that may be a way out of the situation if you believe that you have a strong case, you will not be subject to other bars or no other problems with your employment-based case. All right, so if you do not need a waiver, then it would be probably recommended for you to get an immigrant visa based on employment-based petition itself. Again, these cases are very complicated. You need to work with an attorney. At least attorney has to analyze what potentially what dangers you may face if you leave the United States, how strong the employment case, was information that truthful, if there is any prospects of USCIS try to revoke the petition, because remember, the approved petition may be revoked, fraud, for example. It's very important to remember that. But generally speaking, asylum pending is not a lawful status that would allow you to change status. It does not close that window. So is parole, by the way. It's very, very interesting that parole does not help you. You need to have that lawful non-immigrant status, which can be tourist status, student status, J1, L1, M1, H1, whatever it is, but not that. All right. Now, asylum does stop accumulation of unlawful presence. All right. Properly filed asylum application, so is properly filed adjustment of status application, but that's different from lawful status. You actually can verify what I'm talking about on USCIS website. There is a special, I believe it's called Officer's Adjudication Manual that explains when someone can adjust and when someone cannot. And you can read more about various interesting immigration topics on our website, www.shautsova.com.